Hello, and welcome to Williams Mullen's Benefits Companion, a podcast that helps employers navigate the complex legal challenges of managing their employee benefit plans. I'm your host, Brydon DeWitt, and today I'm joined by my colleague, Zan Gormley, a litigation partner in our Raleigh office. Welcome back to the Benefits Companion, Zan.
Thank you, Brydon. It's great to be back.
Today, Zan is going to discuss the legal tests and standards for what constitutes plan assets. We know that ERISA doesn't really define it very well, but the DOL has given us some guidance, and courts take varying approaches to how to define them. Zan, remind us why that's important.
Well, thanks, Brydon. This is an important topic because it's not as obvious as it might seem. And when you're dealing with plan assets, that is what makes a plan subject to ERISA, first of all. And more importantly, it makes an individual or an entity who's dealing with the plan, like a third-party provider, a fiduciary under ERISA. And that carries with it all the things that being a fiduciary entails. From my standpoint as a litigator, things like breaches of fiduciary duty and prohibited transactions. So it's really important when thinking about ERISA issues to understand what can be considered plan assets. And it's also important, not just from the standpoint of an employer thinking, okay, am I dealing with plan assets, but also an employer thinking about, is somebody that we deal with on a regular basis, like I said, maybe a third-party vendor, maybe an investment manager or someone that the 401k plan, for example, has a contract with, are what they dealing with considered plan assets, especially since if a problem arises, the employer might be able to use ERISA's fiduciary provisions to get some level of recourse with the person that they're dealing with. Hopefully that never comes up, but I'm a litigator and never often becomes often.
Right. And it's important for employers to understand the important distinction of when assets become assets of a plan and no longer part of the employer's general assets, and to treat them as such. As you mentioned, all of the ERISA fiduciary obligations attached to plan assets. And employers, once assets become part of a plan, the employer can't use those monies for anything else, right? They're exclusively to be used for the benefit of participants and beneficiaries and to offset reasonable plan expenses. And so it's important for employers to understand if they haven't maintained an ERISA employee benefit plan, in particular a retirement plan or a 401k plan, when those monies become segregated from their own, when those assets need to be put in trust for a retirement plan, for example, and segregated out from the employer's general assets. You can't pay the light bill with the 401k deferrals, for example.
That's exactly right. And I think you hit on what is the focus of, from my standpoint, this podcast, and why I thought it'd be a fun and important issue to discuss. Because for employers, particularly those who are maybe new to having an employee benefit plan, that's exactly right. There might be money that the employer thinks, well, what are you talking about? This is our money. We earned it. We can do what we want with it. But if it becomes plan assets, in essence, it's no longer the company's money. It's, like you said, it's money that's to be used solely for the plan. And that is where employers can find themselves getting sideways. But as you know, it's nothing that can't be avoided through some careful drafting of plan documents and taking other legal steps, like, as you said, setting up a trust and just making sure that the money is being treated and used appropriately. And the Department of Labor gets the sense that you've been taking an effort to make all that. They're usually willing to work with you, as I'm sure you know.
So tell us, how do you determine what plan assets are?
Well, first, as you noted in the opening, ERISA does not really define plan assets. And I say not really because it does contain a definition, but it's circular and it's unhelpful. It basically states that plan assets means plan assets as defined by the Department of Labor. So it's really the kind of definition that only a congressman punting on his job could come up with. But fortunately, we'll beat up Congress, but we love the Department of Labor. They've stepped up and provided some guidance as to how to identify plan assets. And in an advisory opinion issued going back almost 30 years ago, 1994, I think it was, the DOL stated that plan assets should be based on ordinary notions of property rights. And that is, they defined it as any property in which the plan has a beneficial ownership interest. So, far from being bureaucratese, this is a really clear and helpful standard because it means that to determine if money is something the plan has a beneficial ownership interest in, you look to the same things that you would look to in a traditional dispute over who owns property, right? Things like, what does the contract say? And the actions and representations of the parties involved. So there was some definite logic imposed on that test. Now, of course, it often comes down to the facts, as most litigation and other cases do, but it's helpful that there is a clear standard out there that people can resort to when they're trying to figure out or work with their attorneys to say, hey, are these plan assets and what do we need to do with them? And like I said, under this standard, since you apply ordinary notions of property rights, like I said, you look to the contract. Well, with an ERISA plan, what's the contract? The primary contract is the plan document. So the plan document can go a long way towards defining or establishing what is and isn't plan assets. And as you know, Brydon, that's another thing that's important to consider for employers with plans as they craft or revise or routinely update their plan documents.
Yeah, and there's a difference between types of plans. So you can have a non-qualified deferred compensation plan that's unfunded. There aren't really going to be ERISA plan assets. But on the other hand, if you have a 401k plan with elective deferrals, those elective deferrals are in fact plan assets. They have to be held in trust. So it depends on the type of plan that you have.
Absolutely. So hitting on another thing we talked in the introduction is, okay, so fine. We figured out their plan assets, or now we know the standard for plan assets. Great. Why is that important? And like we said, it's important because under ERISA, an individual or an entity can become a plan fiduciary in a few ways. One is just being designated as a fiduciary in the plan document. We're not really concerned about that because that's so obvious as to not merit discussion. But the one we are focused on for this podcast is what's known as the functional method commonly. That just basically says, it's in ERISA, that an individual can become a fiduciary by exercising authority or control over the management or disposition of plan assets. So when you are looking to see whether an individual has dealt with plan assets perhaps in an improper way, or a company has dealt with them in an improper way, it's really a two-part question. It's, okay, are they a fiduciary? And to determine if they're a fiduciary, you say, first, was the money at issue, the money that was dealt with improperly or perhaps improperly, plan assets? And did that person exercise such a level of control over those assets that it arises to making him a fiduciary? If the money is not plan assets, the person can't be considered a fiduciary with respect to the plan. But if the money is plan assets and that person is found to have exercised that level of control, he will be considered a fiduciary. And that's when that individual opens himself or herself up to all of ERISA's fiduciary standards and penalties, for lack of a better point.
Yeah, and I think sometimes there's a misunderstanding that some people think that you're a fiduciary only if you're designated as such. And you make a good point that it's a functional test as well. So it doesn't matter what matters the plan document says, but you can be a fiduciary even if you aren't identified as a fiduciary in a plan document, or even if a service provider could be a fiduciary, even if the service agreement states that they are not an ERISA fiduciary, but if they actually have discretionary control over plan assets, they're a fiduciary. You can't write yourself out of being a fiduciary. It's what actual authority do you possess? What exercise of control over the plan assets has the individual exercised?
Right. That's exactly right. And where this comes up a lot is, and these fights over sort of whether something is plan assets and whether the control or authority has been exercised over it, is in the context of investment plans, whether, retirement or 401k, who are using third parties to use plan assets to buy investments. And, there's a lot of exotic investment products out there, and plans invest in them because it helps with returns. But a lot of times you'll maybe have a product that has some level of interest float on it, or perhaps has a level of foreign currency exchange baked into it because the plan's buying foreign stocks through an intermediary, and then the stocks have to be converted back into US dollars. And there's obviously an opportunity there to make some money for the intermediary on the exchange rate. And the question is, and has come up in a lot of contexts, typically up in the Second Circuit in New York, is that float or is that exchange money plan assets? And as you can imagine, that's been litigated very heavily. And it's one of those situations in which at the time those financial institutions were engaging in that, they have very good, sophisticated lawyers. And I'm sure they made the conclusion, hey, these aren't plan assets because it's float. It's not part of the plan's money. And of course, the litigation's gone all over the place. So just a sort of story from the ground on how these issues can play out in real life sometimes. The other thing that related to this is you hit on it a little bit, Brydon, but one of these important questions is, are employer contributions to benefit plans, how are they treated? When do those become plan assets? And I think employer contributions are the ones to really focus on, because the DOL, it hasn't even provided guidance. It's provided an actual rule that clearly delineates when employee contributions to a plan, like an employee deferral to their 401k plan, become plan assets. But with employer contributions, there's not yet a rule from the DOL. There is some guidance, but there's not an actual rule. And so since there's only guidance, you have to go with it, but there's ongoing questions. But the DOL basically has issued some guidance that's helpful for employers, because they've said employer contributions become an asset of the plan only when the contribution has actually been made. In other words, I'm an employer, I'm going to give my required monthly match to the 401k plan, but unless and until I contribute that money into the plan, that remains the employer's money up until that time. So that's pretty helpful. And obviously employers like that standard and that rule because for the reasons we discussed, they can hold on to that money as they need to. There is also some guidance from the DOL that, as we discussed, it says plan assets are supposed to be determined by ordinary notions of property rights. So there are some situations in which an employer, if the plan document or other governing plan language gives employees or the plan rights to the contributions as soon as they are due, not as soon as they are made, they can become plan assets. Now, that doesn't, I will say, in my practical experience, come up a lot in the case of single employer plans, because the employers there are writing their own plan documents. And I don't think an employer, if they could help it, would make employer contributions plan assets as soon as they are due. But again, it's just something to keep in mind, because plan language can be imprecise and you don't want to leave it open to interpretation. You, as an employer, want to make darn sure that it's clear that in contributions to your plan do not become assets until they are actually made.
How about employee elected deferrals to a 401k plan?
I believe the rule is that they become assets of the plan as of the earliest date on which the contributions can be reasonably segregated from the employer's general assets. So that gives the employer a little bit more leeway, and that's a more flexible standard, right? But that rule it's in 29 CFR, I think section 2510.3, if memory serves me correct. And that's a pretty bright line rule. And it's given employers, I think, a nice, clear standard to follow. Although, like anything, it can still be subject to interpretation from time to time.
What I've found, it really, in a way, it's a facts and circumstances test. And so the Department of Labor comes in to see whether you've been making deferrals on time and not having delinquent deferrals. They'll look at the history. So with each payroll, how quickly historically has the employer been putting money into contributing to the plan from the employee's elected deferrals out of their paycheck. And so if it's 3 days, 2 days, 3 days, and then you have 5 days, they may ping you on that because, well, you've, in other words, you're kind of punished for doing it so well, right? Because you've demonstrated that 3 days is a period of time for which you can reasonably segregate. That's your standard employer. You've proven that over the last 24 months. And then this 1 month, it took you 6 days. So then you have to explain, well, we changed payroll providers, or the person, there was a holiday, or you have to kind of explain why it took you 6 days when typically it takes you 3. So I would appreciate an even better, there's a clear standard for small plans, but I think it'd be nice if we had a clearer deadline with maybe some leeway. Instead of this kind of facts and circumstances, you kind of establish what you can do, and then you better keep doing that in order to get the assets put into the plan within the amount of time that's you're reasonably able to segregate the assets from the plan. So that's an issue that I've encountered.
Well, knowing that we don't have the magic wand that could make the DOL give us that standard, what do you typically advise your plan clients to do to stay on the right side of that standard?
They just have to pay attention to administrative practices and make sure that they're doing and understand that this rule is there. If it comes up, then we have to go through and determine what was the cause of the delay and to be able to explain it. And then if there is truly a delinquent contributions, there is a correction program through the DOL, the fiduciary correction program. And then there's also prohibited transaction relief, because it can be kind of a big deal because you have fiduciary problems and you also then have a potential prohibited transaction because these plan assets are commingled with the general assets of the employer when they have magically transformed from employer assets to employee assets at that moment in time when the assets could have reasonably been segregated from the employer's general assets. So it could be a tricky situation.
Absolutely. Well, I think your explanation there was a perfect capstone for these points, because it shows that a simple word or phrase like plan assets that's not defined is loaded with meaning and can create all sorts of implications. But like anything in the law, you don't need to be afraid of it. You just need to prepare for it. And forewarned is forearmed, right?
Right. Well, Zan, that'll wrap up our discussion of ERISA plan assets. Thank you for joining us again on the Benefits Companion.
Thanks for having me. Would love to come back sometime soon.
If listeners have any questions or suggestions for future episodes, please contact me. You can also visit our employee benefits page at williamsmullen.com/employee benefits. There you can find out more about our team as well as past episodes of this podcast and legal alerts. And finally, be sure to subscribe to this podcast to be notified when our next episode posts. Thanks for listening.